forgotten that man's name. Was it Watterson? Court rise.
Judgment in the matter of N, a child.
Mr. Watterson asked us to mention to the court that he thanks you for your courtesy. He looked at the train timetable and he's taken advantage of it.
That's entirely reasonable. Thank you very much. I shall ask Lord Justice Jonathan Baker to give the first judgment.
This is an appeal against the judge's decision as to the designated authority under a care order made under Section 31 of the Children Act 1989. For the purposes of this judgment, the background can be summarised very shortly. The child who is the subject of these proceedings, whom I shall refer to as J, was born only 7 weeks ago, shortly after the beginning of July 2021. Until May of this year, his parents lived in a flat in Grimsby, which lies within the area of North East Lincolnshire Council. During the mother's pregnancy, they came to the attention of the local authority Children's Services Department because of a range of concerns about their capacity to care for the baby. It is unnecessary for the purposes of this judgment to spell out those concerns any further. After carrying out various assessments, the local authority concluded the parents could not safely care for the baby. The authority then undertook viability assessments of several members of the extended family and decided that the best option would be to place the baby at birth with the mother's stepsister and her partner, who live in Skegness, some 40 miles away from Grimsby. Skegness lies in the area administered by Lincolnshire County Council. Towards the end of June this year, the parents, having given up the tenancy of the flat in Grimsby where they were living, moved to Skegness, living initially for a short period with the mother's stepsister and partner, before, at the beginning of July, taking on a tenancy of another flat in Skegness. On 7th July, North East Lincolnshire Council completed its care plan, which provided that J was to be placed with the mother's stepsister and partner at birth. The day before that, a social worker from that authority had sent an email to the Children's Services Department in Lincolnshire County Council saying, quotes, "I would like to transfer a case to your area, please," close quotes. This seems to have been the first point at which North East Lincolnshire Council had drawn the matter to the attention of Lincolnshire. On 8th July, J was born in hospital, in a hospital within the Lincolnshire County Council area. The following day, 9th of July, North East Lincolnshire Council started care proceedings and on the same day obtained an interim care order on the basis of the care plan mentioned above. On discharge from hospital, J was placed with the mother's stepsister and partner under the interim care order, where he remains to this day. Lincolnshire County Council did not agree to accept a transfer of the case, and the issue of the designation of the local authority was therefore listed for a contested hearing before His Honour Judge Jack on 28th July. After considering written and oral submissions, the judge made an order designating Lincolnshire as the designated authority under the care order. counsel for Lincolnshire applied for permission to appeal, and after hearing further submissions, the judge granted permission. Thus it is that the matter has come before this court today. The law can be summarised briefly. Section 31, subsection 8 of the Children Act provides, quotes, the local authority designated in a care order must be A, the authority within whose area the child is ordinarily resident, or B, where the child does not reside in the area of a local authority, the authority within whose area any circumstances arose in consequence of which the order is being made. Close quotes. Under section 105, subsection 6 of the Act, it is provided that, quotes, in determining the ordinary residence of a child for any purpose under this Act, there shall be disregarded any period in which he lives in any place, A, which is a school or other institution, B, in accordance with the requirements of a supervision order under this Act, or under an order under section 7, subsection 7b of the Children and Young Persons Act 1969, or C, while he is being provided with accommodation by or on behalf of a local authority. Close quotes. If the purpose of these provisions was to provide a straightforward method of identifying the authority to be designated under a care order, that purpose has not been achieved as easily as might have been hoped. Those provisions have been the subject of a series of reported cases in the early years after the implementation of the Children Act, including Northampton County Council and Islington Council, 1999, 2 Family Law Reports 881, and C, a child, and Plymouth County Council, 2000, 1 Family Law Reports 875, and continues to be a cause of dispute and litigation on occasions, as demonstrated by the more recent decision of this court in Re-S 2017 EWCA Civ 2695 and by the present case. The reason, of course, is that the administration of a care order involves extensive resources, and the pressures that the local authority, all local authorities are under, gives rise to concerns about their expenditure. In the Northamptonshire and Islington case, Lord Justice Thorpe identified the proper approach to such disputes. His guidance was subsequently summarised by Lady Justice King in Re-S at paragraph 18 in these terms. Quotes, 1. The judge's function is to carry out a rapid and not over-sophisticated review of the history to make a purely factual determination. It is a question of fact, not discretion. 2. The subsection should be given the construction that achieves the result for which it is designed, namely, a simple mechanism to determine the question of administration. 3. The subsection has to be read as a straightforward test to be operated by the court in what should be, in the unlikely event of a dispute, to determine which local authority is to be responsible for the care plan and its implementation. Close quotes. Looking at the specific terms of section 31, subsection 8, the first question is the meaning of the words, quotes, ordinary residence, close quotes. As Mr. Justice Cobb observed in Re-M a Child Foreign Care Proceedings Transfer 2013 EWHC 646 FAM, and endorsed by Lady Justice King in Re-S, the concepts of, quotes, ordinary residence, close quotes, and, quotes, habitual residence, close quotes, are close relatives. As Miss Sarah Morgan, Queen's Counsel, for the appellants, observed in the course of the hearing, for us, however, they are not identical twins, because the meaning of ordinary residence is defined more precisely, more strictly, by the statutory provisions referred to above. Nonetheless, the two concepts are closely related, and the one is sometimes defined in terms of the other. The habitual residence of a child is an issue which frequently falls for determination in child abduction cases. This is a topic which has also caused extensive litigation, having been the subject of several cases before the Supreme Court in the past 10 years. The overall approach, however, is agreed to be as identified by the CJEU in Mercredi and Chaff, case C-497/10, 2011, One Family Law Reports 1293, at paragraphs 53 to 56. Quotes, 53. The social and family environment of the child, which is fundamental in determining the place where the child is habitually resident, comprises various factors which vary according to the age of the child. The factors to be taken into account in the case of a child of school age are thus not the same as those to be considered in the case of a child who has left school, and are again not the same as those relevant to an infant. 54. As a general rule, the environment of a young child is essentially a family environment determined by the reference persons with whom the child lives, by whom the child is in fact looked after and taken care of. 55. That is even more true where the child concerned is an infant. An infant necessarily shares the social and family environment of the circle of people on whom he or she is dependent. Consequently, whereas in the main proceedings the infant is in fact looked after by her mother, it is necessary to assess the mother's integration in her social and family environment. In that regard, the tests stated in the court's case law, such as the reasons for the move by the child's mother to another member state, the language is known to the mother, or again her geographic and family origins, may become relevant. 56. It follows from all of the foregoing. The answer to the first question is that the concept of habitual residence, for the purposes of Articles 8 and 10 of the regulation, open square brackets, that is to say, Brussels 2A regulation, close brackets, must be interpreted as meaning that such residence corresponds to the place which reflects some degree of integration by the child in a social and family environment, close quotes. For my part, I would hold that the ordinary residence of an infant is to be determined on the same basis, subject to the statutory restrictions imposed by Section 105, subsection 6. Where an infant is in fact looked after by his or her mother, he or she will share the social and family environment of her mother and also her ordinary residence. Ries concerned care proceedings involving a child of parents living in Leicester, whom the City Council concluded, after pre-birth assessments, should be removed at birth and that care proceedings should be started. 2 months before the baby was due, however, the parents moved out of the city into the surrounding county of Leicestershire, an area, of course, administered by the county council. The child was subsequently born in Leicester Royal Infirmary in the city and removed the following day and placed in foster care again in the city. As Lady Justice King observed at paragraph 7 of her judgment in this court in that case, the child had therefore never lived with either of his parents or in the county council area. Nevertheless, the judge at first instance concluded that the county council in that case should be the designated authority on the basis that the child's ordinary residence, quotes, sits with his mother, close quotes. The appeal against his decision was allowed, with Lady Justice King giving the judgment of the court. She noted that the majority of the Supreme Court in A and another children habitual residence 2013 UK SC 60, had expressed the view, albeit obiter, that a child could not acquire habitual residence in a country in which he had never been present. And she further cited cases from the CJEU to the effect that there was an expectation that a child would have been present in the area in order to establish habitual residence. Lady Justice King concluded at paragraphs 48 to 50 in these terms. Quotes 48. With respect to the judge who was endeavouring to approach the decision-making process in the spirit of Northamptonshire, he was, in my judgment, in error in concluding that LL was ordinarily resident in the county council area and that the local authority was accordingly the designated local authority. Not only has this child not been present in the relevant local authority area, but critically the mother had never been LL's carer, whether primary or otherwise. 49. In my judgment, this is one of those rare cases where a child has no ordinary residence. In the light of the majority view of the Supreme Court in A&A and confirmed by the European Court, presence, in my view, is a requisite before the child can acquire ordinary residence in a specified area. If I am wrong, presence is not an essential ingredient in order for ordinary residence to be established, I am nevertheless of the view that where circumstances arise where there has not only been no presence, but also that the baby in question has never lived with the parent through whom ordinary residence is asserted, that cannot be a basis upon which to make a finding that the baby's ordinary residence follows that of his or her mother's. 50. It follows that, in my view, the judge was wrong to conclude that the county council should be the designated local authority. This case is one of those rare cases where the child in question, having been removed from his parents at birth, has no ordinary residence either in his or her own right or by way of deemed ordinary residence by reference to his or her primary carer. The court must therefore determine the designated local authority by reference to section 31(8)(b). It was accepted by all parties that in those circumstances the designated authority would be the City Council. Close quotes. Turning to the alternative grounds for establishing designation in section 31(8)(b), quotes the authority within whose area any circumstances arose in consequence of which the order is being made, close quotes, it is of course not uncommon for care proceedings to be taken as a consequence of a long history of concerns, for example about neglect or abuse, involving events in different locations. In Northamptonshire and Islington, Lord Justice Thorpe, at page 890, observed that, quotes, the circumstances to which the judge should have regard are the primary circumstances that carry the case over the section 31 threshold, close quotes. In the present case, J has never been present in North East Lincolnshire Council's area. It follows that he has never been ordinarily resident there. Furthermore, both local authorities agreed in the course of the hearing before us that the primary circumstances that carry the case over the section 31 threshold, to adopt Lord Justice Thorpe's words, all arose in North East Lincolnshire Council's area. Consequently, applying the straightforward test in section 31 subsection 8, the question for the judge was whether, disregarding the period in which the child was removed under the Interim Care Order, whether she was ordinarily resident in Lincolnshire County Council's area. If he was, the designated authority must be Lincolnshire County Council. If he wasn't, the designated authority must be North East Lincolnshire Council. That was not, however, the way in which the judge approached the decision. Although he was very properly referred to the statutory provisions and the decision in Re S, he decided the issue on the basis of his assessment of the practicalities. He distinguished Re S, pointing out that whereas the child in that case had been born in Leicester and placed in foster care in the city, and therefore outside the county council's area. In this case, the child was born in Skegness and had been placed in with family members in that town, that is to say, within the county council's area. He observed that Lincolnshire County Council would be in a much better position to supervise the placement with the mother's stepsister, that Grimsby and Skegness are 39 miles apart, that any visits by Grimsby social workers would involve a considerable amount of travel time. And he concluded at paragraph 23 on this basis, quotes, albeit that J did not have an ordinary residence based on his parentage, because he never lived with his parents, he was born in the hospital and placed immediately with other people. I take the view that he has become ordinarily resident well within Lincolnshire County Council area in the Skegness area. His mother and father have chosen to move to that area. That is where J will no doubt have contact with his mother and father, and it is far preferable, in my view, for social workers in that area to have charge of the case, at least for the time being. Close quotes. Following his judgment, as I have said, the Council for Lincolnshire County Council applied for permission to appeal, which the judge himself granted. The grounds of appeal were settled by a junior counsellor who had appeared before the judge in these terms. 1. The judge erred in law in finding that the newborn child had an ordinary stroke habitual residence. 2. In any event, the judge erred in both law and fact in how he applied the test for ordinary stroke habitual residence, substituting his own test of convenience. 3. The judge failed to place the appropriate weight on relevant and irrelevant factors. 4. The judge erred in law in failing to apply both, quotes, a rapid and not over-sophisticated review of the history, close quotes, and section 31(8)(b) of the Children Act 1989. 5. The effect of the decision by the judge is to reverse established public policy. At the hearing before us this morning, Lincolnshire has been represented by Ms. Morgan, Queen's Counsel, who has focused her succinct and helpful submissions on the first two grounds. Her principal argument is that when a child is removed from the care of his mother at or very shortly after birth, he does not acquire her ordinary residence or habitual residence. Unlike Mercredi and Chaff, under Mercredi and Chaff, the acquisition of habitual residence, or for that matter, ordinary residence, by a child from his mother arises when he has been looked after by the mother. In this case, however, J remained with his mother in hospital for a few hours and was removed the day after he was born. In those circumstances, Ms. Morgan submits that he never acquired any ordinary residence from her, and his subsequent placement in the care of relatives under the Interim Care Order falls within the disregard provision in section 105, subsection 6. Accordingly, J had no ordinary residence within the meaning of the Children Act, and the designation of the local authority fell to be decided under section 31(8)(b). In reply, North East Lincolnshire Council elected not to seek to support the judge's reasoning. Instead, a respondent's notice was filed inviting this court to uphold the judge's decision on the following grounds. A. The child had no ordinary residence, and his ordinary residence was that of his mother. B. At the time of the application to designate Lincolnshire County Council as the appropriate authority, their parents had moved to Skegness, having signed a tenancy agreement before the child's birth. C. At the time of the application to designate Lincolnshire County Council as the appropriate authority, the father had arranged a 1-year contract to work in Skegness. D. Lincolnshire County Council has a satellite office in Skegness, so it is not correct to say, open square brackets, as asserted in the Lincolnshire skeleton argument, close square brackets, that any social worker would need to travel a considerable distance to the child's placement in order to undertake their work, and they are the authority best placed to implement the care plan for the child. Close quotes. In her submissions to this court, Ms. Joanna Porter for North East Lincolnshire argued that the fact that the child was in hospital with his mother for a day before being removed was sufficient to establish ordinary residence in the context of the parents' prior move to Skegness, their taking on a tenancy in that town, and the father obtaining employment there. She submitted that, seen in that light, a, quote, rapid and not over-sophisticated, close quotes, review of the history should lead to the conclusion that Lincolnshire County Council is the appropriate authority to be designated under the care order. Both the parents, who were excused attendance and representation at the appeal, and also the child's guardian, adopted a neutral position on the issue before us. I commend Ms. Porter for her sensible and pragmatic approach to this appeal. She rightly identified that the judge's reasoning was unsustainable and has very properly acknowledged that the circumstances giving rise to the proceedings arose in her local authority's area, and she therefore focused her argument on the only realistic point open to her, that the child had in fact acquired ordinary residence in Lincolnshire in the very short period before he was removed from hospital. Despite her impressive efforts, however, I am wholly unpersuaded by her arguments. It seems to me to be obvious that J cannot be said to have acquired ordinary residence in the few short hours before he was removed from hospital. J was not, in my judgment, looked after by his mother, in a sense so as to acquire, so as to conclude that he acquired her ordinary residence. To all intents and purposes, this case is, on this point, indistinguishable from Re S. Like Lady Justice King, I do not consider that a newborn baby removed from his mother in hospital shortly after birth can be said to have, quotes, lived with, close quotes, her so as to have vest in him her ordinary residence or habitual residence. As Macready and Chaff makes clear, a newborn infant will acquire his mother's habitual residence, or in my judgment, ordinary residence, when he is, as a matter of fact, looked after by her, with the consequence that he necessarily shares her social and family environment. Those circumstances simply do not arise in the short period before J was removed from hospital and placed with members of the wider family. This case is therefore materially different from other cases, for example, C and Plymouth, where a child and mother are placed together for a period after birth, for example, in the mother and baby unit. In those circumstances, it may, subject to section 105, subsection 6b, that the child will acquire ordinary residence from the mother. That is plainly not the case here. I understand the judge's concern about practicalities, but as a matter of law, his approach was, with respect, simply wrong. In the Northamptonshire and Islington case, Lord Justice Thorpe observed at page 891, quotes, over the course of years, the swings and roundabouts principle is likely to even out any seeming disadvantage to an individual authority by designation in a particular case, close quotes. That may, with respect, be something of an oversimplification. It may be that certain authorities, for reasons connected with geography, demography, or social deprivation, find themselves designated under care orders disproportionately. But that gives rise to issues that must be settled within government, not by the courts. Our role is to interpret and apply the statutory provisions. In this case, I am quite satisfied that, as a matter of law, North East Lincolnshire Council should be the designated authority under the Interim Care Order, and that this appeal should therefore be allowed.
I agree.
I also agree. Thank you both very much. Now, is there anything else that we need to deal with?
My lord, I don't think so. I was unclear whether it was a slip of the tongue or a deliberate change of gender for identification, jigsaw identification purposes.
It was a slip of the tongue.
If it was a slip of the tongue, I wonder if it might be a straightforward way of minimising the jigsaw identification, which I know is of anxiety on the ground.
Well, somebody in my lords may say one course would be for when we get the transcript of my judgment to send it to you for suggestions about anonymisation.
Yes.
Would you and Ms Porter be able to do that? Would that be
I'd be perfectly happy to do that before it.
Yes, that's fine.
I mean, I did name the local authorities, but
Yes.
I think we should, if they want to make representations about that, we should
Yes.
send them the transcript. They get very touchy.
Yeah. Well, we'll do that, but certainly, speaking for myself, at the moment, as we said at the outset, Skegness and Grimsby are in, because it's not irrelevant.
Yes. I see that point perfectly well.
But everything else, I'm quite happy to adopt my lord's suggestion.
I took quite a lot of detail out of the
Yes.
course of it.
Yes, indeed. It's simply, I wasn't sure if it was a slip of the tongue or not, but it seemed
It
to
was
me
a
to
slip of the
be
tongue.
a fortuitous and perhaps serendipitous, neat way of dealing with what will be on the ground identifiable.
Let's see.
Beyond that, there's
Well,
nothing that I'm
well,
looking at.
when we get the transcript through, we'll send it
Yeah.
to you.
Anything else?
Not from me.
Thank you very much. Miss Porter, anything?
My lord, no, not for me,
No.
thank you.
Thank you very much. And I repeat, Miss Porter, what I said at the outset, that it's notwithstanding the fact that your concessions were entirely correct, that doesn't mean that in this court they're always made. So, speaking for myself, I would particularly share my lord's commendation of you and your submissions.
I'm grateful.
Thank you very much.
Good argument on Plymouth Point.